Hmm?
All right, so we're missing one juror. But the court is going to call 2022 CR 8529, State of Texas versus Melvin Jones. Could I have parties announced for the record for the state?
Daniel Escobar and Lindsay Shaw for the state.
Robert Porter for Mr. Jones, we're ready.
All right, and are you Mr. Jones?
Yes.
All right, so what's going to happen is both of you all will rest and close in front of the jury. My understanding from my memory states you've already rested, so we just need the defense to rest and close. So before they are brought in, I want to talk to you all about the jury charge. Both parties, I've given you three different juries. Charge. One is the charge as is with the offense that's listed. One is a charge that contains one lesser included offense, which is the possession less than a gram. One charge is a charge that contains the original charge plus two lesser includeds. One is possession less than a gram. One is possession 1 to 4 grams. So is there any suggestion over which charge? Defense, are you asking for any lesser included?
Yes, Judge, we are just asking for the lesser included of possession less than 1 gram.
All right. And state?
Yes, ma'am. The state's asking for the lesser of possession 1 to 4 grams.
All right.
And Judge, the state was also going to ask that the charge is styled at the top.
Well, let's do one step at a time, then we'll get to the next one.
Yes, ma'am.
So is there any objection, state, to the defense's request for possession less than 1 gram?
No, Judge.
Defense, any objection to the state's request for possession 1 to 4 grams?
No.
All right. Now, the next issue is with regards to the way the charge is styled. State?
Yes, Judge, it's styled with his middle name, Melvin Todd Jones. That's not the way that we indicted him, so we're just asking that Todd be removed.
Any objection?
No objection.
All right. And then defense, is there any other requests you're asking?
Just extraneous offense. Be included.
All right. And that will be a general. Just 1 second. I'm sorry. The charge writer is texting me. All right. So with regards to the extraneous, any objection, state?
No, ma'am.
All right. So that will be admitted. And I'm going to have the charge writer send that to us. My understanding, she's working on it now from the text that she's just given me. And then how much time are you all asking for closing? State?
15 to 20 minutes, Judge.
Defense?
Based on just a half a day of testimony, Judge, this should be a 15-minute clip.
All right. I'll give you all 15 minutes. Does anyone wish to have a warning?
Yes, Judge, when I have 2 minutes remaining.
Defense, any warning?
5.
State, are you splitting up your time?
No, Judge, reserving it for this final.
Okay. All right. Thank you. Can you mute us, please? Hey, just 1 second. No problem, Bob. All right, any objection to the charge of the court, state,
Not from the state judge.
defense?
Not from defense, Your Honor.
All right, are both parties ready to proceed? State, defense?
The state's ready.
Defense ready.
All right, Deputy Lawyer, if you could bring the jurors in.
Oh, I hope I don't. Good luck, sir.
They're all best friends already.
Mhm. We previously had a jury trial that lasted a month.
Hmm.
So they really got to know each other.
Oh, God, I know which one you're talking about.
Yes,
Which one was that?
and they still are in contact with each other.
Jesus. Yeah. Defense attorney. And
Yes, we're ready.
right, for the jury.
Yeah, I think my cough is from the too cold water. Mhm. All right, everyone, please be seated. All right, state, yesterday you rested, defense.
Defense rest, Your Honor.
State, do you close?
Judge, resting close.
We close.
All right, ladies and gentlemen, what's going to happen now is I'm going to read to you the charge of the court, or what's known as the jury charge. You don't have to memorize the charge. The charge will go back with you when you give your deliberations. But after I read the charge, the state and the defense will have a chance to give closing arguments to you. Charge of the court. Members of the jury, the defendant, Melvin Jones, stands charged by indictment with the offense of possession of a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 4 grams or more, but less than 200 grams, alleged to have been committed on or about the 20th day of June 2022 in Bexar County, Texas. To this offense, the defendant has pleaded not guilty. 1, our law provides that a person commits an offense if he knowingly or intentionally possesses a controlled substance. Methamphetamine is a controlled substance. 2, by the term possession is meant actual care, custody, control, or management of the controlled substance. Adulterant or dilutant means any material that increases the bulk or quantity of a controlled substance, regardless of its effect on the chemical activity of the controlled substance. 3, a person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct, A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. 4, now, if you find from the evidence beyond a reasonable doubt that on or about the 20th day of June, 2022, in Bexar County, Texas, the defendant, Melvin Jones, did intentionally or knowingly possess a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 4 grams or more, but less than 200 grams, then you will find the defendant guilty of the offense of possession of a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 4 grams or more, but less than 200 grams as charged in the indictment. And do not consider any of the lesser included offenses of the charged offense that are instructed in paragraphs 5 and 6, and do not fill out any of the verdict forms related to the lesser included offenses as instructed in paragraphs 5 and 6. But if you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of possession of a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 4 grams or more, but less than 200 grams as charged in indictment, say by your verdict not guilty of the charged offense of possession of a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 4 grams or more, but less than 200 grams. And next proceed to paragraph 5 to consider whether the defendant is guilty of the lesser included offense of possession of a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 1 gram or more, but less than 4 grams. 5, now, if you find from the evidence beyond a reasonable doubt that on or about the 20th day of June, 2022, in Bexar County, Texas, the defendant, Melvin Jones, did intentionally or knowingly possess a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 1 gram or more, but less than 4 grams, then you will find the defendant guilty of the lesser included offense of possession of a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 1 gram or more, but less than 4 grams, and do not consider paragraph 6, and do not fill out the verdict form related to the other lesser included offense as instructed in paragraph 6. But if you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant of the lesser included offense of possession of a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 1 gram or more, but less than 4 grams, say by your verdict not guilty of the lesser included offense of possession of a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 1 gram or more, but less than 4 grams, and next proceed to paragraph 6 to consider whether the defendant is guilty of the lesser included offense of possession of a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount less than 1 gram. 6, now, if you find from the evidence beyond a reasonable doubt that on or about the 20th day of June, 2022, in Bexar County, Texas, the defendant, Melvin Jones, did intentionally or knowingly possess a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount less than 1 gram, then you will find the defendant guilty of the lesser included offense of possession of a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount less than 1 gram. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of possession of a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount less than 1 gram. You are instructed that if there is any evidence before you in this case regarding the defendant having committed offenses other than the offense alleged against him in the indictment in this case, you cannot consider said evidence for any purpose. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, or Twitter, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of the law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether the defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is hearing given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching a unanimous agreement if that can be done without violence to individual judgment. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of his guilt at trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to your jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and verdict forms are attached. State, are you ready to proceed with closing?
Judge, the state reserves our time for a final closing.
All right. Defense, are you prepared to proceed?
I am, Your Honor.
All right, you may proceed.
Thank you. Thank you, ladies and gentlemen. On behalf of Mrs. Fitzsimon and of course, Mr. Jones. We talked a little bit about our importance of jury trials. I want to let you all know this is the most important day of Mr. Jones's life. And I know you take your job very, very seriously. This is a very short trial in part that been going on for days and days, even though y'all felt like you've been here for days and days. I always get nervous when I come up to do closing arguments. I get nervous when I do closings or trials in general, simply because, like I said in Bordar, I love the law so much. I always get nervous about where does my fellow citizens sit when it comes to our bedrock, fundamental laws. Is it still where I believe they should be, or are they being watered down? But I've watched you all during this trial. You've taken good mental notes of what was happening. And I take comfort in the fact when the judge asked you all that each of you do solemnly swear or affirm in the case of the state of Texas versus Melvin Jones, you will true verdict render according to the law and the evidence, so help you God. And that gives me some comfort that we at least are here to apply facts to the law. I'm going to make this brief and I'm going to make this simple. It was a very convoluted, complex jury charge when it came to, is it 4 to 200 grams, 1 to 4 grams, less than a gram. I think it's going to be very easy when we say just not guilty on this first one, and we don't have to move on at all. And let me tell you why it's not guilty. Because when we talk about the law, some of you are sitting there saying, well, the dope was right next to him, therefore it is his, and that's good enough for me. And that worries me all the time because we are a society of things happen quick. I mean, we're always on our phones doing stuff. I want quick answers. But when we start applying the law and what was really said from the stand and what really happened was simply this. We have to look at what the law says about possession. And we have to look at it, what our jury charge says, and our real law is the presumption of innocence and beyond a reasonable doubt. Because during a jury trial, we're not here for would-haves, could-haves, probablys, most likely's, clearly. Some of you may sit there and think he clearly possessed that stuff, and let's wash our hands and let's go home. But we're not here for that either. We're here for beyond a reasonable doubt. That's our bedrock principle. So why is there doubt? It's very, very simple. I'm going to give you the easiest one on doubt. You have the evidence. The state of Texas has always had the evidence of the meth itself. Think about this. Mr. Jones, I did not do this. He stood up before you and said, not guilty. State of Texas said he's guilty. Easiest, most fundamental thing they could have done is check those bags for fingerprints, for DNA, for anything. If his stuff is on it, he's a liar and you convict him. But if it's not guilty. Didn't do it. It wasn't his. That's their burden, as the jury charge says, the presumption of innocence. It's their burden to produce all the evidence. It's very easy. I talked to Detective Hernandez about that. Well, you know, it's a drug case. We usually don't do it. It's not that important. Let me tell you why. It's extremely important to Mr. Jones. It would be extremely important to any one of you or your family members that were sitting next to me. You check that stuff out to sit there and say, how do I get from probable cause to beyond a reasonable doubt in this jury charge? Because you know what? She sat there and said, I felt I had enough probable cause. Okay, so what else did you bring to the jury to get by our stair step from probable cause? What did you bring this jury to show, okay, we found drugs, we're at probable cause, now I need to move up a burden. Now I have to move up another to preponderance of evidence. Is it more likely or not? They brought you nothing. How do I get to clear and convincing? Well, nothing. The fact of the matter is simply this. Actual care, custody, control, and management. There's a reason the pen example we did during or dire. Just because something is within reaching distance of you, and even if you know it's there, does not make it possession. It's in your car, does not make it possession. The mental state tells us intentionally, you have the intention to do it, and knowingly you knew you were doing it. So the only causal connection that they have with Mr. Jones to any of the drugs is in this green bag. Okay. Again, quick assumption, it's his bag. We talked about assumptions. They're deadly in the jury trial. There's been no evidence at all. There was 2 other people in that car. I didn't see either one take that stand and said, that was Mr. Jones's bag. All we heard was officers sitting there saying, we saw him carry that bag into the Bolero. Now, when we get to credibility of witnesses, as the state correctly pointed out, differences and stuff, does it go to the elements of the crime? Okay, as Officer Jordan sat there and said, he saw Mr. Jones go in and out of that Bolero a few times, right? The other 2 detectives sat there and said, went in and then came out and left. Now, does that go to the elements of the crime? No. But let me tell you something. The reason they brought that up, and he said that, is just so y'all would think, he must be doing something nefarious in there. Right? Just kind of get your mental juices. He's a bad character. Look at how he's coming in and out. But it didn't happen. Okay? Officer Nieto and the stop. He looked like he was eluding us. You'll have that video in front of you. That's why I simply asked if there's an officer without his lights on driving down the street and I take a right and I take a left, you're gonna feel like you're eluding. The reason he said that is to sit there and say, well, Mr. Jones probably knew we were following him and knew he was gonna pull us over. When you watch that video, how do we know the lights are not on and when they are on? It's very easy. Watching the camera on the screen, you'll see words come up that says LB light bar on. Okay, and you'll see when the lights actually turn on and where Mr. Jones was at that point in time. Okay. That's the only evidence they have, and it's real easy to sit there and say, "Well, look at Officer Jordan walked right up to the car and saw those drugs there." Therefore, the assumption is we're going to pin to the closest person that we knew was there. But there's nothing that links them there. Because I asked him, When were they put there? How were they put there? Who put them there? I don't know. And there's a person in the back seat right there. I asked him how far it was, 12 to 18 inches, could have been put there. I'm not gonna play the would have, could have, should have game because. Sorry, start getting. I'm not here to play the would have, could have, should have. Facts and the law. Okay? And it's easy to sit there and say, drugs in the car, he was carrying that backpack. Therefore, that's good enough for me. And that scares the hell out of me because it's not. It's not, especially when the police can do something when the court of law to get us to what beyond a reasonable doubt really is, right? And here's an example. That's why I asked Officer Nieto, when you search that vehicle, you search a purse. Do I know whose purse it was? No. I'm not going to assume that. When you looked at it, was there an idea in there? Yes. Does that still prove that that purse was that person? No, but it makes it link it there. It gives us something else. It may get us to clearly, right? That like juror number 12 sat there and said, maybe the cloud, when we were talking about the rain example, maybe the cloud may get us there, get us almost there. Just had crack pipes in there. Or I shouldn't even say she, but they had crack pipe in that person. But in that green bag that we're talking about, there was no identifiers of who it belonged to. So I guess the moral of the story is this. If anybody asks you to carry a bag, I guess you better start looking through that stuff because the state's gonna say it's possession if there's something in it. But that is not the law, right? He is guilty if we believe all the detectives, which I have no reason not to, that he carried that bag. He intended to carry that bag. There was no intent or knowledge that he was carrying drugs. There's been no evidence of that. Something hit me during this trial that really didn't make a lot of sense. It was this, you look at the weights of the drugs and where they were at. In the bag itself, it's less than, and that's why you have the other options as far as less than a gram, 1 to 4 grams, 4 to 200 grams. In the bag was the less than a gram, right? So I guess it's the state's theory to sit there and say, he is protecting his drugs by carrying around the bag, and he's just gonna leave the big bag with bigger number just sit in a car. And then Officer Nieto says, well, I saw the driver moving around. I don't know whether to believe it or not. That's why I have to listen. The car has tinted windows and it's packed up to the gills. Again, that is stuff just to get your juices flowing and sit there and say, aha, he must have been hiding it. Assumptions are deadly in a trial.
5 minutes.
Thank you, Your Honor. Assumptions are very deadly in a trial. Everything the state says outside of where the drug was found and carrying a bag, they have to have you make an assumption to fill in the blanks. That's what scares me about what a reasonable doubt is. And that's what scares me about presumption of innocence. I get up every morning and I go to work and kiss my wife goodbye. And she says, what are you doing today? I said, I'm going to go talk to my 12 new friends. And I'm going to see where we stand as a society, Bear County, as far as what beyond a reasonable doubt means or presumption of innocence. So because this case, the verdict has not been made, it could be assured. It's the state's verdict to do that. Ladies and gentlemen, it's time to go see the second doctor. That's what beyond reasonable doubt is in this case. I want to thank you, everybody, but it's definitely enough.
All right, state.
So I really wanted to briefly cover what we do know based on the evidence presented. Because the state presented the evidence that we had. We're not trying to hide the ball. I'm not trying to say there's other things out there that could have. I'm dealing with what we could prove. So Sergeant Jordan spotted the vehicle entering the gas station. He saw it without a front or rear license plate and called it out. He also saw the defendant exit the vehicle from the driver's side carrying a green bag. He then said that he saw him go in and out of the store, but then enter through the driver's seat and then drive away. And that was backed up by what Detective Hernandez said. She also said she saw him carrying that bag. It's 2 different witnesses from 2 different angles who saw the same thing. And I think that's significant because at the time when they saw that, they didn't know the significance of him carrying the bag. They didn't know there was anything in it. but they both independently said, we saw him carry that. It became obvious later. So then he gets pulled from the vehicle, he gets detained. And again, Sergeant Jordan testified that he saw that same green bag right there. It's right there on the center console. You can look at his body cam and it's right there. That's a nice thing about entering all those body cams into evidence. You can go back to the jury room and watch them. We weren't able to play you the co-ban from the actual stop because of technical difficulties, but just want to let you know, at about 1 minute and 4 seconds, that's when the defendant parks into the driveway. At about 1:30, you can see one of the officers appear from the driver's side and kind of take a look in. At about 2 minutes and 20 seconds, you can then see the back passenger roll down their window and stick their hands out. At about 4 minutes and 43 seconds, that's when the defendant comes out. The back passenger comes out at about 3 minutes and 26. So it took her roughly from when she showed her hands to when she exited, about 1 minute. From the stop to when she rolls down the window, about 1 minute. But from when the stop to when he got out, we're talking about 3 minutes and 45 seconds. It's a lot more time. Now, Sergeant Jordan testified that he immediately saw those drugs. It wasn't as if he searched around and had to look, had to move anything. He said, we watched the video with him. He said, oh yeah, I walked up and you could see him. That's drugs, that's it. He pointed it out and said, that's when I saw him. And you can see in the body cam, because it doesn't always capture a perfect angle, it's not attached to his head, it's attached to his chest, that he bends over and there are the drugs right there. Plainly obvious to anyone. Those are the drugs found in the door frame. The other methamphetamine is found in that green bag. Okay. He testified again that he's the one that saw him enter and exit the car, go into the store, leave the store, all the time carrying that bag. It care, custody, control, management. He had that bag. The drugs in the door frame, he had care, custody, control. He was the closest person to them. And he easily reached down and had about 3 minutes to put them in. That's not things that we're asking you to assume. That's what's in evidence. Also, there was plenty of testimony about the bag itself that pretty much empty. There really wasn't much in there, except for the methamphetamine. So I want to talk more about the drugs found at the door. So 2 options there. Either the entire time before he was detained and after he left, the drugs were always there. Well, guess what? They're almost instantly obvious. I know that Mr. Porter mentioned the pen example and saying, well, I mean, if you find a pen on the ground and then you pick it up and give it to me, you really possess it, you know it's there, you know it. I think it's a little different when it's methamphetamine and you see it in your door frame. If I walk up and see it in my door frame and I see a bag of methamphetamine, I'm not going to say, well, that should just be there. That's going to be a huge problem. Be patently obvious to anyone who entered and exited that car that it was there. Now, the second option that Mr. Porter mentioned.
Judge, I'm going to object to again, the state misleading the jury as to what possession is. Again, just because an object is there and you know it's there, that is not possession.
All right, ladies and gentlemen, the jury, the law comes from the court. The law does not come from the attorneys. Does everyone understand? All right, thank you. You may proceed.
Care, custody, control, management. They're normal definitions. We're not trying to make it something bigger than it's not. Now, if you think about it, the other option that Mr. Porter brought up was, well, what about that back passenger? What if they were there? They were hers. So it took her about a minute to get out of that car. Officers approached with guns drawn. This was a felony stop. They didn't take their time. They weren't just, looking away down the street. Their attention was fully on that car. She would have known that there are officers with guns drawn on her. So in that minute, the defense is asking, well, maybe she's the one that put it there, the one we 12 to 15 inches. So then she would have taken the time, so she would have been very cool under pressure, probably ice water running through her veins, for her to get the drugs from wherever she had them. And then in that minute, carefully sit down right there in the back passenger seat, reach your arms through, put them there. And then reach back out, get back up sitting without anyone noticing, even though there are guns drawn on this vehicle. These officers know that the danger could come from anywhere. Someone reaching down in that area where they don't know what's down there. No one ever said that they saw her do anything like that. Not in evidence. The other thing is that if you take a look at the body cam, that car's filthy. There are items everywhere. There are bags everywhere, clothes everywhere. It's complete disarray. And so instead of assuming the defense wants that she did it, and she's the one that's put it there. The other option is, with a better assumption, they hid it somewhere else. If she was gonna hide it in that car, there were multiple other options she could have done. She could have easily thrown them in the back. No one would have known who they belonged to. Stuck it in another bag. She could have done all those things, which are so much more easier than what they're asking you to think. Third option is the defendant can put them there. That's also another option. Out of those three, which is more reasonable? So then, let's talk about the drugs in the back. So again, we have multiple officers come in and testify that they saw the defendant with that bag, care, custody, control, management. Also testimony, bag was nearly empty except for the drugs. Who walks around with an empty bag? Just in and out. They're concerned about what's in that bag. What's in there? It's methamphetamine. That's a pretty easy assumption. That's a pretty easy conclusion. Is that you're going to be taking that bag in and out if you know what's inside. Because you want to protect it. Now, the officer's credibility. You notice that whenever both myself and the defense, whenever anyone asked them questions, even difficult ones that they didn't know the answer to, they were honest. They didn't try and say, well, we know he's the one that put them in there, or that we know that he's the one that bought the drugs, or that they're his, because we don't. And they were honest about that. They weren't trying to hide the ball. They weren't trying to make our position seem better. They just told the truth, like doing their jobs. Another thing was about the plastic bag and to do the fingerprints. Because I asked about that once, Detective Hernandez spoke about that with Mr. Porter. Well, the reason why fingerprints weren't taken is because it's a plastic baggie. Fingerprints don't really come off of that well. Which you tried? Sure. But they don't come off that well. Now, again, the methamphetamine was within reaching distance. It would have been plainly obvious to anyone getting in and out of that car that they were there. Now, there's been no evidence on them being someone else's drugs or someone else putting them there. Can't consider that. That's not a fact at issue. What we are asking for you to do is to apply the law to the facts that the state's presented. We're not trying to hide the ball. We're not asking you to make assumptions. We're asking you to make logical conclusions based off of what's been presented. The state has met its burden. We've proven that he had possession, not ownership, possession of the drugs that were in that vehicle. Both. We're asking you to find him guilty of the possession of 4 grams and 200 grams. Thank you.
All right, ladies and gentlemen, you've received all the evidence you will receive in this case. I'm going to ask for Eckert and Martinez, Dominique Martinez, if you can remain behind for me, please. All right, everyone, please rise for the jurors.